Good evening, everyone. Thank you for your patience. I'm going to call the State of Rhode Island Coastal Resources Management Council's Rights of Way Subcommittee to order. Today is Tuesday, June 10, 2025. I would ask that the record reflect the subcommittee members that are present, as well as CRMC staff members that are here this evening. First matter on the agenda will be approval of the minutes from April 8, 2025. I know Lisa had disseminated them. I would entertain a motion to accept those minutes as presented unless there are any corrections that are put forth.
Move approval.
A motion has been made to accept them and approve them. Is there a second?
Second.
Motion has been seconded. All in favor, say aye. Aye. Anyone opposed? Motion carries unanimously. Next is staff report.
No staff report tonight, Mr. Chair.
Thank you, Mr. Willis. Before subcommittee for discussion and action in the matter of Spring Avenue extension, number one, Rhode Island Attorney General proponent's motion to assign to hearing. A, the WFD objection to proponent's motion to assign to hearing. Do we want to take them like in order like that, or you want to read all of them or?
Please read them.
Okay. Number two is the Weekapaug Fire District. It's a motion to compel privilege, log and documents. Small letter A, Rhode Island Attorney General's objection to motion to compel answers to interrogatories. Number three, Weekapaug Fire District. It's a notice of intent to file dispositive motion. Number four, Carolyn Contrata's motion for protective order against the continued deposition of Joseph Priestley. Small letter A. The WFD objection to Contrata's motion to protective order against the continued deposition of Joseph Priestley. And last would be adjournment after that. So our first matter is the Rhode Island Attorney General's proponent's motion to assign to hearing. Good evening. I'm going to turn it over to Attorney DeSisto for any comments or logistics for the procedure.
Okay, well, this motion, excuse me. The motion to assign has been pending. I know that there's an objection to that, as well as some ancillary motions here on discovery. Ms. Boots, are you comfortable going forward without hearing these other issues first?
I would think that it might be prudent to hear the other issues first in order to get to the motion to assign. That way we have those either fully decided or we know it's not decided. Could we hear this motion last in the series?
That's what I was thinking. Perhaps if these other issues are resolved, it may be determinative on this motion.
Correct. Thank you.
If I may, Attorney DeSisto, good evening to the subcommittee. I prefer that the motion be taken in order. I'd like to add two grounds for our objection to that order. The fact that I became aware of a document about 2 hours ago, a 1940 town council report that postdates the supposed 1939 dedication of this right-of-way, according to the proponents, and lists out the rights of way in the town of Westerly and does not list Spring Avenue extension. I bring this up now because I did not receive it in discovery, despite having asked for it. Had we had this document in our possession during discovery, we would have been able to inquire with witnesses about it, in particular, the expert witnesses put forth by the town and Ms. Contrata. Our discovery clearly asked for this document. It was known to the town of Westerly because it was presented as recently as a March 2023 council meeting. And I think that the discovery of this document alone provides substantial basis for our objection to the motion to assign this matter to a hearing in the near future. There's going to be work that's going to have to be done around this document in order to flesh out what it says and what it means. And it's possible that this document could wind up being the exculpatory document that would resolve this matter on summary judgment in favor of the district.
Two questions.
Please.
The first question is, how did you obtain it?
We came into possession of the document this afternoon. Beyond that, I don't have much background to give on it.
Okay,
We located the document attached to the meeting minutes for the 2023 town council meeting.
okay, so it's part of research.
Correct.
Okay. Does the document speak for itself?
I believe that it speaks quite loudly. I believe that it does speak for itself. But we have expert witnesses in this case who have made much of the 1923 statute and certain stampings on a map that appeared in 1939 that isn't considered by this document, which postdates all of that activity. So I do think it speaks for itself, but I also don't see how we could examine those expert witnesses live without having the chance to examine them at a deposition on this document beforehand.
Why not? I'm asking, why not?
Yeah, because the document has an impact on what their opinions are going to be. And if their opinions would change as a result of seeing this document, it might be that they would actually give testimony supportive of the fire district's position when confronted with this document, which would obviate the need to go forward with a hearing when they're going to testify for the very first time about the document. And those continued depositions need not be day-long affairs. They need only last a few minutes. But I think the fact that this document was in the town's possession and control and not provided to us may have also been in the possession and control of their AG's office, as well as Ms. Contrata, and known to them, and not turned over, prejudices us and should inure to the district the ability to take some follow-up discovery.
If I may address the council on behalf of the town.
Sure, come right up.
Hi, my name is Sarah Tool. I represent the town of Westerly. I haven't seen this document. Attorney Farside represents, he just discovered it about 2 hours ago. So I don't know what he's talking about because I haven't seen it. However, in responses to the interrogatories and requests for production, we did provide a list of all of the town council meetings that did discuss the Spring Avenue extension. All of the documents, as he stated, are listed on the clerk-based website and are easily accessible. So the town wasn't trying to hide anything. I don't know what he's talking about. I haven't seen it. However, the town does receive a lot of documents at town council meetings. Sometimes members of the public come and they just hand stuff out to the members of the council. So just because something was handed to the town council at a town council meeting doesn't mean it can be properly authenticated or that it's a document that belongs to the town. And I'm happy to take a look at the document and comment further if needed. Thank you.
If I may, I would just add to what Ms. O'Toole said, that even if the document, which I haven't seen, is a town generated document, there are, if you go into the town hall, the town of Westerly, go to the clerk's office, you see 2 full levels of books containing documents. I don't think that any one person would know what is in every possible document of every deed book or every town council minute book that's there. So congratulate Mr. Farside for finding something. I don't know what it is, but that doesn't, I don't think there should be any insinuation that anybody knew of a document was hiding, given the volume of documents that are there.
The AG's office also does not know what this document is. We have not been provided with the document, and I don't believe that it was in our possession.
That's total bullshit. I'd like to speak on the matter if I may.
Hold, please.
I have firsthand information on it.
Hold, please.
I'm a recipient witness.
So, my question here is, on this, and this is more addressed to the board than anything else. There's a document, that purports to be from the town of Westerly. I'm sure it is. I'm sure we'll have a certified copy at some point. That I believe is going to be used to impeach expert witnesses. So, you know, at this late stage in the matter, I don't know if there's a difference between having it as a deposition. You have another deposition of these witnesses say, look, I found this, how come you didn't? Or just when we go ahead and have this hearing at some point, that's going to be used for impeachment purposes, I'm assuming. And that's why I asked whether or not the document speaks for itself. If this document was is in the Westerly records, at the town hall to the town council, and you're going to use it to impeach them because you're going to say, look, you've given expert opinions without seeing this document, I'm not so sure that a deposition is needed on it. I don't know how many more depositions we need until it finally comes to a hearing. This is not a court proceeding. It's really an administrative procedure that's been going on now for years. It's going to be a lot of documents. So I'm not so sure we need to continue on with this. You have the document. I'm sure you're going to share it, and we'll go from there. That's only my opinion on this. I'm just saying that, to me, you're gonna have a deposition to impeach a witness. I don't know why I just don't do it right at the hearing. Really don't.
Well, it's not necessarily to impeach, it's to see if they'll change their opinion. And if their opinion changes, then the need for a hearing might be obviated. So it's not just to impeach respectfully, it's to see if they'll change their opinion altogether.
It's gonna have to be a hearing anyway. I mean, we have a recipient witness here for the public. This is not, and I'm gonna say this again, this isn't a court hearing. This is really an administrative hearing. It's a public hearing. And at some point, there's going to have to be a hearing. There is.
I don't take any issue with the fact that there will be a hearing, and my view is, and this also goes to our, the notice we filed, of our intent to file a summary judgment motion, is a hearing on this is going to be quite sprawling,
Yes.
time consuming. And there are two main components of this case. One is this idea that this statute created a dedication, and the other is that the dedication happened by a recording of plats and that people walked over this parcel. And this particular document would end, in my view, the whole statutory dedication theory and potentially cut any hearing here in half, if not more, by negating the need for particular witnesses, lay or expert. So while I hear what you're saying, counsel, about the hearing, I do think there's a role to play in terms of whether these experts would change their opinion and obviate a hearing altogether on the statutory dedication.
Thank you.
I have a question for our counsel. Would the party be prejudiced if we don't allow the continuance for deposition?
I'm gonna ask a further question.
Okay,
Is this in connection with Mr. Priestley? Like, who are you gonna depose in
So-
connection with that document?
Mr. Priestley, Mr. Shea, and Mr. DiOrio. They are the experts for Ms. Contrata, the town, and the Rhode Island Attorney General's office, respectively.
Priestley's a lawyer, DiOrio's a surveyor,
Correct.
the fellow in the middle?
Justin Shea's a lawyer.
Okay. And he's testifying for?
Town.
The town of Westerly.
Thank you. Okay. So you have a request on the Priestley deposition. And that's expanding to these other two individuals. And a further basis, other than what you've had in your papers, is this late discovery of this document that you just got today.
The late
Correct.
discovery of the document is the reason for looking at the other experts beyond just Mr. Priestley. Correct.
Are the other attorneys ready to address this request?
I'm certainly ready to address the request with respect to Mr. Priestley. But, you know, there's obviously now two requests with respect to Mr. Priestley, it seems.
That's correct, yes.
Okay, now turning to this supposed smoking gun or silver bullet that we have here, there's two reasons why it wouldn't affect Mr. Priestley's testimony, and I'm sure he could tell you that when he takes the stand in front of you. And we've waited a long time to actually hear witnesses in this case. It's not a recorded document. It's not in the land records. He's a title attorney. He searches the title, he searches all the land records. And he says, based on the land records, this is who owns it and who has an interest in it. And who has an easement in it. And, you know, we would further argue that that which is in the land records and established as title in the land records can't be undone by an extra record item. And that's especially the case with public rights of way, where it's indicated that in many a case, that long periods of town neglect or oversight does not detract from the publicness of a right of way. You can't undo a public right of way in that way. There's been cases where the town has actually acted against the public right of way and it hasn't undone the right of way. So I have a feeling that this is like really a lot of a tempest in a teapot, a lot of sound of fury that's at trial or a hearing will amount to nothing. But of course, Mr. Forsythe is free to cross-examine at the hearing. I mean, no, we're never going to get to a point of absolute perfection of knowing possibly everything, else you wouldn't play the game, you wouldn't have a hearing. So I don't think it's a smoking gun. I don't think it affects a title opinion, which is based on the land records. And for those reasons, I'd say there's no need to rehear or reopen Mr. Priestley's deposition on this account. Do you want to hear my argument on the other part of this motion, or can we wait on that?
No, why don't you go ahead?
Okay, so there's a notion that we have to get into his Mr. Priestley's communications with Save the Bay. I believe that it's been pretty much established and agreed to that there was only one communication with Save the Bay. That was a meeting that was in early 2024. His report was filed with this subcommittee in December of 2023. That report is part of the record. You have it. It's done. It was done several months before this meeting. So how can discussions at this meeting affect what he put in the report? I think that what Mr. Forsythe seems to want to get at is that somehow something was said to him by Save the Bay at this meeting that somehow altered his report, but his report was a done deal at that point. So I don't believe it had any relevance, and I do believe that when an entity puts up $15,000 towards the hiring of an expert, which Save the Bay, I'm very grateful, did in this case, I think that that in of itself constitutes common interest privilege, a sufficient fact to underlie a common interest privilege amongst the council in this case. The testimony at the deposition, first part was that there were three people at the deposition, all attorneys, Mr. Priestley, expert witness, and an attorney, myself, and Kendra Beaver of Save the Bay. And Kendra Beaver, if Save the Bay put up $15,000, that seems to be putting their money where their mouth is in terms of establishing conflict of privilege.
Mr. Rubin's wrong about that. He might believe that, but he's wrong. The case law is clear that just even paying somebody's legal fees, forget about paying Ms. Contrata's expert witness fees, which is another step removed. Even paying somebody's legal fees doesn't put you into the cone of attorney-client or common interest privilege. That's like black letter law. So the fact that he went out and was able to secure $15,000 from Save the Bay doesn't make his correspondence with Save the Bay or his meetings with Save the Bay protected by some kind of privilege. There needs to be a common legal interest in order for a common interest privilege to apply, and there simply wasn't here. And his report might have been authored in 2023, but he was deposed in 2024, months after this meeting happened. Months after he met with Save the Bay and said to Save the Bay, I want $5,000 more to complete my work. And Save the Bay said no. Well, they met for 45 minutes to an hour, and I can't believe they just talked about the weather the whole time. And the idea that he went and asked for the money and may have, as an expert, indicated to Save the Bay some of the weaknesses of his report, which then led Save the Bay to be reticent to give him more money, is something we are entitled to discover, because Save the Bay is a third party who is not protected by the common interest privilege in its discussions with Mr. Rubin.
Thank you. Who's,
I don't need to respond. I already said my piece. Thank you.
yes, thank you. Who's next?
I would just like to briefly.
Excuse me, Mr. Palazzolo, you know, you've said before, you're not here as an attorney. These are legal arguments being made. These are not fact, we're not getting into the factual issue. These are actually, they're making the legal arguments.
Still, back, they'll probably have the documents Mr. Farside is talking about, because I gave it to him multiple times. I discussed it in public.
Thank you very much, but they're legal arguments now. It's not appropriate for you to be even saying anything. Go ahead.
May I just briefly respond about whether or not additional depositions are needed of our experts because of this document? The thing that I'm just looking at, because this is the first time I have looked at this document as part of this case or just ever, is this document doesn't state what the scope of the work was that this committee supposedly did to look at rights of way. Spring Avenue Extension is not mentioned on it. However, that doesn't mean that Spring Avenue Extension was never accepted by the town or never accepted by the public. This report came out after a lot of the plats that are relevant to this case were recorded, stamped by the highway board, recorded. We don't know why that's not included. And this frankly is just not relevant to whether or not the attorney's opinions on the recording of the plats, following the public laws, following the common laws, was actually achieved.
Can I ask a question? This is part of the Map Street ordinance?
I don't believe so.
Okay, thank you.
I will just note that one of the three authors of this document is Louis Rossi, the same author of the 1939 map that Mr. Rubin so often cites.
Thank you.
I don't think the Attorney General's office has anything to add beyond what Attorney Rubin and Attorney O'Toole have stated.
Mr. Forsythe, do you have anything else on your motions? I know you have this notice that you're going to file a summary judgment, but I don't think that needs to be addressed at this time.
I don't think so either.
Okay, do you have anything else?
Just that we have a number of outstanding items, some of which we've already discussed here. And one more is the, one additional item that we haven't discussed, and I don't think we are getting to it yet, is our motion to compel the AG's documents from their privilege log. But it might be that the subcommittee wants to consider, debate, and decide certain of the motions we've already discussed, unless you want to go into.
No, but I do think what you did, thank you, you're correct. That's a separate issue. But you did ask for the Attorney General's motion to set the hearing down, I guess, the schedule.
Yes.
So it seems appropriate that that should be heard now. I think the subcommittee can take up all the issues together on that and handle the motion to compel separately.
Sure.
Can I just say some things on that piece then? So we've heard the motion regarding Mr. Priestley. We're discussing the motion to assign, and this new piece of evidence as well. But I just want to be clear on which parts you would like to hear argument on.
It seems to me that the main objection to your motion is that discovery is not complete for what Mr. Farside has just been speaking on, not only that document, but also that he had other matters. He wanted to depose Mr. Priestley on this issue of Save the Bay. And that's what they were looking at. I think we've heard all of that. The subcommittee's heard that. They should hear your motion and then decide them all kind of seriatim.
Sure, okay, so regarding the motion to assign, the standard for assigning to hearing is that the discovery is substantially complete. I believe that discovery is substantially complete. I understand that the fire district has some outstanding concerns, many of which, or I believe all of which were brought up in reaction to our filing the motion to assign for hearing. The matter is substantially ready. We have been waiting for years to get this to hearing. The fire district has been upset that we've been waiting for years to get this to hearing. We're finally at a place where it is substantially complete. Any remaining discovery can be completed in, I would imagine, a matter of months. So if we schedule this for hearing in, say, September or something along those lines, I believe that that would be more than enough time to satisfy any of the fire district's outstanding concerns. And that would move this matter along, not only for the public, not only for the attorneys and parties arguing, but also for the subcommittee, so that you may really begin considering other rights of ways and giving those rights of ways the attention that they also need. We've already moved to the point of needing to do every other month for this so that those other rights of ways may be considered. We're so close to wrapping this up and getting to hearing and coming to a final decision on this. And I don't really see any reason why we don't just get that scheduled, get that on the books and start moving towards that conclusion. Thank you.
Thank you.
Yeah, the fire district sees it a little differently. We have a piece of land that is being claimed as being open to the public by two governmental agencies and an intervener individual. We view that as very important to the fire district, to its fabric. The fire district is not concerned itself with other moving things along for other reasons. It's concerned about doing this matter correctly, litigating this matter to the point where we know what we're dealing with. We go to a hearing, we can do this hearing efficiently and correctly, and not without skipping over discovery that should be finished. I'm not saying the discovery can be finished in the timeline Ms. Boots laid out, but this is not about racing ahead. This matter's been pending since 2020, and I'm sure a couple of additional months to make sure discovery is completed isn't going to prejudice anybody here.
If I may, I'm not advocating to skip over discovery. I do believe that some discovery is substantially complete. The parties are in a posture to move forward with, of course, enough time for the fire district to complete their remaining discovery matters that they take issue with. We have no interest in impeding or standing in the way of discovery, just setting a time limit for it.
Are you saying that you can't conclude your discovery prior to September?
I'm not saying that, and I thought I mentioned that a moment ago. Forgive me if I wasn't clear, but it does depend on some cooperation from the other parties involved as well. So we have a motion to compel against the Attorney General's office that we'll argue in a couple of minutes. And the outcome of that and the outcome of the APRA litigation, which is still awaiting a decision, continue to kind of thwart our efforts to finish up the discovery that we think should be finished in a different manner than it currently stands.
I have to add.
I agree with everything that the Attorney General said. The only thing I can add is that I believe it was June of 2024, you asked us to submit all of our transcripts stipulated facts, stipulated exhibits. It seemed like about a year ago, you wanted us to be ready for a hearing. Since then, we've been picking away at different discovery matters. I think we're done. I think we have everything ready for all the substantive issues that actually matter to this case. The town is ready to go forward. We want to go forward. I think we're completely done with discovery.
If I may, if there are any loose ends, I can't imagine that, we can't accomplish them by September, a date certain in September. I mean, there hasn't been any lack of cooperation from the fire district. I thank them for that, and I don't think there's been a lack of cooperation from us, the proponents. There's no reason, there might be some loose ends, there might be a supplementation or something like that, but at a certain point, you got to call it over with. And I would echo what Ms. O'Toole said, which is that you gave us a date back in 2024. It was the summer of 2024 when all discovery was supposed to be done. Now, things come up. I understand from witnesses were just discovered late or were not available or whatever, but now we've had a full year, and yes, there might be a couple of loose ends. I think we can get them done and be ready to go for a hearing. We can't make the perfect enemy of the good.
Thank you.
And the only other thing, I don't know if there's going to be a chance to address this notion of a motion for summary judgment, which I think would delay it further. I don't think the rules allow for a motion for summary judgment. I don't see anything in the Administrative Procedures Act, and I don't.
Mr. Rubin, that's for another day, and
Okay.
I understand your argument, but that's for another day.
But I was hoping to preclude it in advance, but thank you.
Well, thank you.
Thank you.
On this issue, the proposal from the Attorney General is to set the matter down for a hearing in September. That's plenty of time to conclude whatever discovery may be outstanding. We've gotten a lot of information on this. I think at some point, the public has to have their opportunity to speak on this once these issues get done. I have to tell you, you have a lot of information here. My recommendation would be based on the timeline proposed by the Attorney General to grant the motion. Now, a few things have to happen. One of them is we have to get a place down in Westerly for the hearings. And those arrangements will have to be made most likely with the town. I don't know if there's any state buildings down there where this could be held. And we'd have to make arrangements to make sure everybody can attend. But I do think the motion is in order for granting. It seems to me that it's a reasonable request. And that one should be taken up first. That was the proposal from the fire district that it be taken up. Then we can address the other issues, including the a motion to compel afterwards.
So it's number one on our agenda, correct?
Correct,
What
yes,
you're referring to.
yes.
Okay. Is there a motion from the subcommittee?
I would move that we assign the matter to a hearing based on the Attorney General's timeline. Find the date, September 2025, schedule the first hearing.
Is there a second?
Second.
You need to say something.
No.
Motion made and seconded. Any discussion? Hearing none, all in favor, say aye.
Aye.
Actually, I'm gonna hold it. I'll do a full, roll call vote. Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
I too, Raymond Coy, vote aye.
I'm gonna propose that you have a second motion attached to that. And that is that you delegate to staff to select an appropriate location in the town of Westerly for these hearings. And to further coordinate dates and times based upon the selection of that site.
Do I hear that in the form of a motion?
I'll motion that we delegate to staff a selection of a building in the appropriate community, along with setting the appropriate dates and times.
Is there a second?
Second.
Motion made by Ms. Reynolds, seconded by Mr. Gagnon. Any discussion? I'll now Poll the subcommittee, Mr. Gagnon,
Aye.
Ms. Reynolds.
Aye.
I, Raymond Coy, vote aye. What's the next? Vote on the list.
Well, we discussed the deposition of Mr. Priestley. And there's a motion, I guess, for protective order on that, as well as a motion to renew the deposition of Mr. Priestley based on this one discrete issue, correct?
That's right. The issue is his meeting, the content of his meeting to Save the Bay in the spring of 2024.
Okay, and there's a motion for a protective order on that.
That's correct. I did indicate that the renewal of the deposition was procedurally improvident without a motion by them to renew their motion to compel. So that's how this came to the council, and it was left pending. I mean, this is a procedural technicality. And in their counter, they said, treat this as a motion to renew if you find that necessary. So I kind of think it is their motion. So you can think of it as my motion for protective order. It's the same thing.
Okay, I'm not so sure that's relevant to the matter at hand. However, there is a request to depose Mr. Priestley based on this new document.
Well, I think that'll be handled separately via separate notices of deposition,
Okay,
which if folks want to make motions on at that point, they can do that.
okay.
But I just have to say, if we are going to depose Mr. Priestley, and I hope that the answer is no, I would think that it should all be done in one deposition. But well, I guess that's contingent upon what you do.
I don't disagree with that.
So what you have pending, I think, is the motion for a protective order on a deposition on this discrete issue of the conversation with the Save the Bay lawyer. I'm going to tell you that I'm not so sure it's relevant, particularly with what we heard tonight earlier with this new document. So my advice would be to grant the motion for the protective order as to that one discrete line of inquiry.
Is there a motion from the subcommittee?
I'd move we grant the motion for the protective order based on that one discrete line of inquiry.
Is there a second?
Second.
The motion's been made by Mr. Gagnon, seconded by Ms. Reynolds. Any discussion? I'll pull the subcommittee, Mr. Gagnon,
Aye.
Ms. Reynolds.
Aye.
I too, Raymond Coy, vote aye.
So the final issue is this motion to compel the privilege log in documents in the Attorney General's objection.
Thank you. Good evening again to the subcommittee and council.
Oh, okay.
I want to read a couple pronouncements from the Rhode Island Supreme Court. The attorney-client privilege protects from disclosure communications by a client to his attorney for the purpose of seeking professional advice, as well as the responses made by the attorney to such inquiries. The privilege must be narrowly construed because it limits the full disclosure of the truth. Communications made with third parties and/or not intended to be confidential do not fall within the attorney-client privilege. And finally, the party seeking to invoke the privilege, here the Attorney General's office, bears the burden of showing to you that the privilege should apply. The AG's office voluntarily barged into this matter. It's not here involuntarily like the fire district is, as has been forced to defend itself. The AG's office wrote a letter in November 2022 telling you how you should hold in this matter. The AG's office knows it can influence processes like this, use its political heft to do so. It's only fair that when confronted with an attack like this, the fire district have a fair chance to discover what the Attorney General's office has about the matter at hand. Otherwise, the AG's office can simply say what it wants, when it wants, with zero accountability. It just does not satisfy notions of basic fairness. Despite all that, the AG's office is withholding 2,367 documents from the fire district. claiming various types of privilege apply. Some of these documents are protected by the attorney-client privilege or the attorney work product doctrine, and we've indicated in letters with the Attorney General's office that we don't challenge those documents. What we seek here are documents that have been disclosed by the AG's office to third parties, especially entities like Save the Bay, to the general public, which means they are no longer privileged. There's just no argument that they're privileged. There are 819 documents being withheld by the Attorney General's office from the fire district, despite that they were external to the AG's office. The law is clear that once a document is disclosed to a third party, the privilege no longer applies. This is called waiver. The common interest privilege is an exception to waiver, where a communication with a third party can retain protection even though the privilege would otherwise have been destroyed. But that's the exception and not the rule. The burden, again, is on the Attorney General's office to establish that some common interest privilege applies. And we've stated this in prior hearings. It's not enough that you have the same rooting interest and you get to have a privilege cover your communications. We, Save the Bay, want this to be a public right of way. So you, Attorney General, go do the work and we'll do some work for you in the background. No, there's not a common legal interest there to give rise to a common interest privilege, a privilege that would obscure the disclosure of the truth. Emails that went outside the AG's office are not protected by the privilege, especially communications with Save the Bay. Save the Bay admitted at its deposition that they had no common interest agreement with anyone, let alone the Attorney General's office. In fact, the question made to Save the Bay was, do you or your organization, Save the Bay, have any common interest agreement or joint defense agreement? Let me make it first with respect to the common interest agreement with other parties, the Department of Attorney General and others involved in this matter. Answer, no. Question, you don't? Answer, no. It couldn't be any clearer. Communications with Rhode Island saltwater anglers, another rooting interest that doesn't give rise to a common interest privilege. The AG's office has even claimed communications with members of the public, people who were not seeking the advice, legal advice from the Attorney General's office, but giving the Attorney General's office information that they hope the Attorney General would use in connection with this effort to turn the Spring Avenue extension into a public right of way. The AG will point to the fact that it provided us a privilege log with over these 2,300 entries. But the log itself is woefully inadequate. It has 200 entries, 10% of the total, that are emails without a recipient to the email. And they ask us to go on faith that based on the privilege log, those documents should enjoy a privilege. We can't go on faith. Again, we're talking about over 2,000 documents. It's hard to believe they even generated that volume of documents about the Spring Avenue extension. We do continue to await a decision from Judge Raspallo in the APRA litigation. I do think that that decision is relevant to this issue here, which is the Attorney General's ability to claim common interest privilege applies to external communications. We haven't received that decision yet, and we think it could come down any day. That being said, the Attorney General's office, if you're to believe what they say, they can communicate with anybody in the state, or maybe anybody anywhere, and say, well, we're the public's attorney. We don't have to turn over our stuff. We can send a letter telling this subcommittee how to rule. We can intervene in the matter to bring extra pressure on the fire district. And we're not going to disclose what we have. We're going to put our 2,300 documents on a privilege log and tell you too bad. That can't stand.
Can I ask you a question?
Please.
The case that's pending in Superior Court,
Yes.
it's for these 2,000 documents?
It relates to them because we sought these documents through APRA requests. And we were not given satisfactory responses to the APRA request, which led to the litigation. But the litigation will result in a ruling one way or the other, whether these documents can be withheld. At least that's our view of it.
Thank you.
Regarding the APRA litigation, we do believe that it will be relevant and that that decision will be relevant. We are hoping for a decision to come down any day now from Justice Respallo. I do want to touch on quite a few different things in my brother's argument regarding whether or not we can converse with the public. Attorney Farside has overstated that the documents that Attorney Farside points to in his motion to compel that were related to the public or from the public were actually attachments to protected documents. So the proponents do have a common interest privilege. The subcommittee, the courts, and the fire district itself has referred to the town, the AG's office, and Ms. Contrata as collectively the proponents. We have filed joint motions, we have filed joint discovery. There is pretty clearly a common interest there. Documents that are attached to emails are protected within that common interest of work product privilege, and that is because those are the attorney who is sending those documents over email. Those are their impressions, those are their strategies. It was their strategic choice to include those documents and to send them to us. They become privileged. Whether the document is privileged outside of that is a different question, but in that context, it's privileged. Whether there's additional writing on it, that becomes privileged. Whether it is opined on in that email, it is privileged. Those documents are privileged in that context at the very least. The only documents that the fire district points to where the public is addressed or involved were attachments. So I do want to make that first part clear, and I believe that is a document involving a gentleman named Ben Weber.
Can I ask a question?
Yes.
The legal issues that are being discussed here, are they the subject of the case that is currently in order for decision by the Superior Court?
I don't understand the question, sorry.
The same legal arguments that are being made here on both sides. Is that what's happened in Superior Court?
At the APRA litigation?
Yes.
So I am not the attorney on the APRA litigation, but my understanding is that there is significant overlap. I don't know that it's completely identical.
Mr. Farside, can you answer the question?
Substantial overlap, yes.
Okay,
The same or similar arguments being made.
yeah, we should. Gonna tell you what, premature for it to be decided at this time. My recommendation is that the matter be continued for a status next month. If there's a decision, either way, just so long as we know, not saying you have to show up. But just if you can continue the matter for the next month on that one issue for receipt of a decision from Superior Court.
On the entire issue or on the entire motion or on just common interest privilege?
On the entire motion.
Okay, understood. Thank
May
you.
be moot, by the way, if depending on what the Superior Court decision is. If there's an APRA request, I'm assuming then that the documents would have, if under APRA, the documents are considered to be public documents that should be forwarded, then the district will get those documents and it'll be moot here anyway. So we'd just like to know. But thank you very much. Very good arguments.
Thank you.
Thank you.
Could I inquire what date that meeting might be? Sometimes the meetings are the second Tuesday, sometimes the fourth.
This would be the second,
It would be the fourth Tuesday.
I'm sorry, fourth.
No, it'll be.
And that's just for status purposes.
Hmm.
If there's a decision, you're probably not gonna have to attend. We just wanna keep it active.
Makes sense. Thank you.
What else?
Just to move to continue and then move to adjourn.
Move to continue.
Second,
Motion made and seconded to continue. Any discussion? Hearing none. Mr. Gagnon.
Aye.
Ms. Reynolds.
Aye.
I, Raymond Coyle, vote aye. Motion been made to adjourn.
Second,
Seconded, any discussion? Hearing none, all in favor, say aye.
aye.
Aye. It passes unanimously. We are stand adjourned.
Thank you.
Thank you.